Next month, a UK Supreme Court case might shatter women and girls' rights as we know them. It will define or redefine what it means to be a woman, and potentially strip away all of the rights and protections that women and girls have in safe spaces. So in this video, I'm going to briefly outline what this case is going to talk about next month and how it might result in a legal absurdity. Now, I don't mean that as an opinion, I mean it as a legal absurdity, which I'll explain in this video. First of all, if you do like my content, which I hope to be a fresh, open, honest account of what I see happening in the media and in the news, please do consider subscribing to my channel, not least of which because it will help my channel grow and lets YouTube know that you enjoy my content. And on that note, I'd like to thank the 150,000 of you that watched my video yesterday on a similar topic, whereby there was guidance which I believe was, in my opinion, was irresponsible guidance given to schools across the country that insisted that trans people should be allowed to use the bathroom of their choice, irrespective of a gender recognition certificate, which is something that plays a big part of in this video's discussion. I asked you to like that video to tell YouTube that you liked the content and to avoid it getting flagged and shadow banned or whatever the term is. And I'm pleased to say over 17,300 of you liked the video and a 99.4% like to dislike ratio. So thank you very much for doing that, and I'd appreciate that if you do that on this video as well, just to show YouTube that you like this content. It is intended to be educational, legally informative, and to raise these things as discussion, because I believe it is vitally important that we discuss these things and not just leave them to the powers that be, because otherwise no one really has a say in these things. Now, the only way for law to really change is for you to vote for the party that you wish to get into power, and for that party to then create law, either by making new law or repealing or amending old law. Speaking of old law, the subject of this video is what you might think of as old. Now, speaking of old law, some of the law we'll talk about in this video is relatively old, in that one of the acts I'll talk about, the Gender Recognition Act, is from 2004, but we still use very old law today, even from 1861, the Offences Against the Person Act of 1861. You'll be familiar with the phrases, you might be familiar with the phrases, especially if you watch my channel, of a Section 47 assault, a Section 18 assault, which is more serious with intent, and Section 20 if it's without intent. Now, as far as law goes, it doesn't matter if it's old, it is in force unless and until it's repealed, amended, and changed, and so on. And so the Gender Recognition Act of 2004, this is the real nub of this video. The Gender Recognition Act provided that under Section 9, where somebody obtains a gender recognition certificate, they, for all the purposes of the acquired gender, so that is, reading from the Act, if the acquired gender is the male gender, the person's sex becomes that of a man. And if it's the female gender, the person's sex becomes that of a woman. And there are, of course, certain requirements to obtaining this certificate, such as living in the acquired gender, obtaining a report by a registered medical practitioner practicing in the field of gender dysphoria being one of the requirements. Now, at that point, I will say that this video is in no way intended to discount the effects of genuine gender dysphoria. That is where somebody in their mind believes that they are the opposite sex to what they are born with as their body. They believe they are a woman when they are born as a man, and vice versa. Rather, this video is to focus on the law and how this might be defined in the upcoming case in the UK Supreme Court next month. And this will follow the case of judicial review between For Women Scotland Limited and Lord Advocate. This was specifically in respect of two protected characteristics. Those protected characteristics arising from the Equality Act 2010, the first being the protected characteristic of gender reassignment, and secondly, the protected characteristic of sex. In short, the conclusion of the case that is now going to the Supreme Court was that this guidance did not conflate the two separate protected characteristics. It said a person with a gender recognition certificate, that is, someone who's gone through the full process of obtaining the certificate, possesses, first of all, the protected characteristic of gender reassignment for the purposes of the Equality Act, and separately, they also protect the protected characteristic of sex according to the terms of their gender recognition certificate. Now, the reason I say that this will result in a legal absurdity requires something of an example. Allow me to give you an example. Let's take, for example, somebody who is born as a woman, and there's no ambiguity. Biologically, they are a woman. They possess all of the biological characteristics of a woman. But during their lifetime, they have genuine gender dysphoria. They follow the procedure of getting a gender recognition certificate. And legally, they then have the protected characteristic of both gender reassignment and, according to this case thus far, which is going to appeal in the Supreme Court, they then have the protected characteristic of the sex of a man, which is their acquired gender. If they are then, for all purposes and for the rest of their life, they have the protected characteristic of being a man under the law, then let's say that because biologically they remain a woman, they are then still able to get pregnant and then do go on to get pregnant. Then naturally, upon becoming pregnant, they require medical attention. Now, let's say that certain hospitals have women-only sections which categorically exclude men from those sections for the protection of women's rights and dignities. Then the hospital is obviously unable to provide that treatment. And the only solutions to that would be A, to exclude the person completely, which would be direct discrimination under the Equality Act. B would be to provide a duplicative service on the whole to cater solely for transgender persons, which is just not going to be feasible for a hospital, I would presume. Or C, to eliminate the rights and exclusivity of that space for women and allow the transgender person into that area. And thus the result is something of a legal absurdity, in that the exclusively women's space would exclude the transgender man's access to it, even though biologically still a woman, or just ignoring women's rights in those spaces altogether and allowing the transgender man into those spaces. But that, of course, will not be the only example of where this potentially causes a problem. But first, just allow me to explain this principle of a legal absurdity for a moment. And so, taking a completely different example, that of bigamy, that is the offence of going through the process of marrying someone when you are already married. This remains an offence under Section 57 of the aforementioned Offences Against the Person Act of 1861. So old law is still good law sometimes, although this particular one is of note to law students, particularly probably in the first or second year of your law degree, which is the description of a legal absurdity. Now, here's the wording and I'll explain why it's absurd. So first of all, this is the offence of bigamy, that is, getting married when you're already married, or so the wording might suggest. Here's the wording. It says, "Whosoever, being married, shall marry any other person during the life of the former husband or wife, whether the second marriage shall have taken place in England or Ireland or elsewhere, shall be guilty of felony, and being convicted thereof shall be liable to be kept in penal servitude for any term not exceeding 7 years." And so here's why the wording is absurd. If we take that literally, there are two counts on which that phrasing is absurd. Firstly, the phrase that says "shall marry another person" is meaningless in the sense that a married person cannot marry again because the original marry subsists. And secondly, the reference within the wording of former husband or wife is obviously inappropriate because it suggests that the original marriage no longer exists. But if that is the case, then they're not guilty of the offence. So it's a circular argument and therefore it is absurd. And so in this whole video context, I stress that the wording absurd is not one of opinion, it's one of a legal absurdity in that it results in something which is either a circulatory reference or contradictory in nature. And so this is when, and again, interesting for law students, is we have what we call, first of all, the statute, which is the wording of an offence. We have a literal interpretation, what the words literally mean. And then we have what we call the golden rule. And this came about with the case of Crown and Allen, which is where the court realised the absurdity because it was a circular reference, contradictory in nature, and resulted in an absurd wording. And so the golden rule allows judges to essentially choose a different meaning to what was written in statute in order to avoid absurd results. And so with the greatest respect, when we look at both the Equality Act, which is intent on protecting protected characteristics, one of which being sex, the other of which being gender reassignment, and read that in line with the Gender Recognition Act, which was from 2004, so some 6 years apart, these two pieces of legislation. The Gender Recognition Act says that for all purposes, the person that obtains a full gender recognition certificate acquires the same protection of that of their acquired gender, that being the sex of whatever gender they acquire. But then does that automatically mean that they acquire the same, and here's the real question, which is going to be decided in the Supreme Court next month, does that mean biological sex, or just the sex that they've acquired with a gender recognition certificate? Now, none of this is to discuss someone who is self-identifying. That's a completely other discussion. This is solely focused on those that obtain a gender recognition certificate. So however way you discuss this, they are serious in what they say. They have genuine gender dysphoria. They genuinely feel that in their mind and inside, they are the opposite sex to which they were born or assigned at birth. Therefore, they go through the process, they obtain the medical reports and so on, and they obtain this gender recognition certificate. Then the question is, do they obtain the same protection as a biological person of their acquired sex? Many people watching, I suspect, will say no. Many people, I believe, watching will say if you are biologically a woman, you have a different protection than a person who was born biologically a man who gets a gender recognition certificate as a woman and should not share the same legal protection of the protected characteristic of the sex of a woman. I did do a poll to this effect yesterday, and I believe now at the time of recording this there are 16,000 votes. My question was, should sex as a protected characteristic in the Equality Act refer only to biological sex and not the acquired sex, as per the Gender Recognition Act of 2004. 17,000 people voted, and 95% said yes, it should protect only biological sex. And 5% saying no, it should also protect the acquired or the trans sex of the person who's obtained the gender recognition certificate. Now, the reason that this will be essentially set in legal stone next month by the Supreme Court, unless and until the legislation changes, which I'll clarify in a moment, is because the UK Supreme Court next month is going to decide whether or not these two protected characteristics are conflated, those being gender recognition and the protected characteristic of sex. The UK Supreme Court is going to decide whether that arises out of biology or simply obtaining a gender recognition certificate. If the court decides that it doesn't matter whether you are biologically born a woman to obtain the protected characteristic of being a woman, then many people will feel, now this is me observing from polls and from what I read, many people will take the view that this is eroding women and girls' rights to women-only spaces and so on, because it will essentially mean that someone who is born and remains biologically a man who has obtained a gender recognition certificate will then have access, legal access, protected legal access to women's only spaces, if indeed they've obtained a gender recognition certificate to become a woman. They will be legally protected as a woman for all purposes for discrimination under the Equality Act 2010. And that means that any person and any organisation must not discriminate against someone with a gender recognition certificate, either to be a woman or to be a man, under the Equality Act 2010. Now, there's a further legal absurdity here, because all of this may run counter to other parts of the Gender Recognition Act of 2004, one of which being where I mentioned sporting organisations can and arguably should exclude trans persons from a male or female category in their sport for the purposes of protecting the safety and the fairness of its participants. However, if the UK Supreme Court next month decides that the person acquires all of the same protection as the biological sex of their acquired gender, how can that then be fairly applied with the other parts of the Gender Recognition Act, whereby these, for example, the sporting organisations can exclude participants on those bases for the protection of its participants? The answer is something of a legal absurdity, because on the one hand, the Act says these organisations can exclude people. On the other hand, the Equality Act says it would be discriminatory to exclude people. And there is also another argument between services offered generally to the public and those within the workspace, and that, again, with the involvement, irrespective of a gender recognition certificate, is a whole other discussion which will probably take up a whole other video, which I will probably do if you're interested in this type of content. Again, I stress this is not to insult or upset anybody. This is a legal explanation as to how this law applies, how it matters, and I think it really does matter to discuss these things, because I think a lot of people are afraid to discuss these things for the fear of getting it wrong, the fear of being criticised. But at the end of the day, these laws exist, these laws are being decided, and these laws will have a long-standing effect on the whole of the population. And so as a legal education channel, I thought it would be remiss not to cover this subject at all, and I attempt to do so with the greatest respect. So please do like the video, subscribe to the channel, hit the notification bell to make sure this video is not suppressed so that more people see it. Do leave your thoughts respectfully, please, in the section below. And let me know your suggestions for future videos and other questions that you might have that arise out of this issue, what you need to do about these sort of things, and how you can protect your organization. And with that, I thank you for your kind attention. I thank you for watching.